is Engineer Asuncion Ventura Lopez. She is a graduate of Bachelor of Science in Civil Engineering at the Far Eastern University, Manila, and gained her Master of Laws degree in Construction Law and Arbitration at the Robert Gordon University, Aberdeen, United Kingdom. Engineer Asuncion is a registered professional civil engineer of the Philippine Professional Regulation Commission, or the PRC, and with the Ministry of Municipality and Environment Committee for Accreditation of Engineers and Consultancy Offices of Qatar. She is also a chartered member of the Royal Institute of Chartered Surveyors, or RICS. Asuncion has over 20 years of wide professional experience as a civil engineer, quantity surveyor, and contracts administrator. She has worked on a range of infrastructure and building projects with strong experiences in assessing claims, liabilities, disputes, risks, and variations, as well as review of contractual documentation, tender analysis, and contract administration. She is also an experienced trainer of PACQS Structured Training Program, a part-time lecturer of Philippine Institute of Built Environment Incorporated, or PIBE, and CPD speaker on various seminars and events. Ladies and gentlemen, please help me in welcoming Engineer Asuncion Ventura Lopez.
Hi, good afternoon, everyone. Thank you so much for inviting me here to the webinar of United Architects of the Philippines. So allow me a few seconds to share my screen. Oh, may I request the host to please allow me to share my screen? Thank you. Can you confirm if you are seeing my screen?
Yes, ma'am.
Okay, thank you so much. So again, welcome and good afternoon. Our topic for this session is about force majeure in construction contracts and its application to construction, to COVID-19 crisis. So, okay. I am sure many of you know that force majeure is roughly translates to superior force. So let's start with the abstract of this presentation. Force majeure clauses are common to standard forms of contract. However, it is badly defined in many cases. Some contracts provide simple provision for termination in the event that performance is prevented by force majeure, while there are also clauses that provides complex criteria and many conditions. Now, it is often used when referring to unforeseeable events that taking place, such as the current situation of COVID-19, we are referring to force majeure. Similarly with what happened in June 2017 during the Gulf diplomatic crisis, if you would still remember, or this is what we call the known as Qatar blockade. The contractor's recent concern is if the delays or the additional costs that has been incurred or will be incurred in their current projects will constitute an event of default or force majeure under the current contract. So we will try to discuss this in the next few slides. Now, this presentation will discuss the force majeure provisions in international and local standard forms of contract. For the international form of contract, we will see how the force majeure contract provisions differ between the FIDIC 1999 and FIDIC 2017. In the local standard form of contract, we will look through the PWA 2014 provisions. So although we are not lawyers here and most of you are architects, we will still take a peek of the Qatar Civil Code And let's have an overview of the exceptional and unforeseeable events recognized under the Qatar law. At the end of the presentation, we will summarize the possible reliefs for contractors from the adverse impact of COVID-19, and we will provide practical advice for future considerations of the drafters of the contract agreements. Now, this presentation is divided into 6 parts covering these topics. Of course, we will have an introduction. We will have some overview of the COVID-19 crisis at the early part of this year. We will try to define and provide the criteria of the force majeure. And we will look into the international standard form of contract, which is the FIDIC rainbow suit. And we will also see PWA 14 as one of the local standard form of contract. As I have said, we will take a peek of some of the provisions of the Qatari Civil Code. And at the end, we will have some conclusions. So now proceeding to the first part, let us refresh ourselves on the initial reports of COVID-19, which was initially or formerly known as nCoV-19, if you still remember. We are all aware that the first official report came from Wuhan City, Hubei province of China, when the World Health Organization, or WHO, was initially informed of the detected cases of pneumonia, which is of unknown cause. And this was happened, if you would still remember, at the last week or later part of the December 2019. A few days later, a total of 44 patients with pneumonia of unknown etiology was reported by the national authorities in China. Then on around the mid of March 2020, WHO Director General categorized the new coronavirus, particularly in March 11. And then the COVID-19 was declared as a pandemic. At this time, there are already more than 118,000 cases reported in over 114 countries, and about over 4,000 people have already lost their lives at the mid of March. Individual and governments around the world have implemented emergency measures to delay or stop further spread of the virus. And this includes imposing travel bans, local and abroad. There are individual and community quarantines is happening, suspension of commercial flights. What else? Prohibiting foreign visitors to enter the country, restriction of social interaction. As you have observed, we were required to have at least 1.5 or 2 meters apart when we are going to public places. And there are implementation of curfew hours in some of the countries. Most of us have experienced for sure the working from home and has some limited attendance at the office or at the schools. And even the parks and beaches were previously closed, although we know that at the moment they are now starting to open gradually. So almost everyone is talking about claims or contract relief against force majeure event. But what is the precise meaning of force majeure? Do we really understand the true meaning of this term? Force majeure is a French term that literally means superior force. It was derived from the Roman law term vis major, wherein its function is to set a limit to the strict liability for non-performance of an obligation. Vis major also means an accident which cannot be foreseen or averted because of human infirmity, such as earthquake, flood, storm, or it could also be an incursion of an enemy. It could also be a violent attack by robbers or pirates in the sea. However, the simple cases of theft is not counted into this. Now, Roman law recognized the principle that possibility is the limit of obligation, meaning no one is held to do impossible things. So that's why we are now trying to refer with to the term of force majeure. Now, even though force majeure is a French term, as I've earlier said, interestingly, it was not defined in the French legislation, wherein the meaning of the term is commonly left to be worked out by doctrine and the courts. The term has been applied in most legal systems, both in domestic and international law, and it's said to be a shield to invoke liability when an unforeseen event is happening beyond the control of the party that makes it impossible for them to perform the obligation stated in the contract. Now, there are three criteria that must be satisfied for an event or circumstance to be regarded as a force majeure. And one is externality, which means it must be beyond the control of the contracting parties. And there must be an absence of causal link between the event invoked and the acts of the party invoking it. Second is unpredictability. So from the word itself, it means unpredictable, which means it cannot be anticipated. It's foreseeable. It is not expected. So no one expected that COVID-19 will be here with us for the whole year of 2020, right? Third is irresistibility. So what does it mean? It means it is unavoidable. And of course, you would all agree that no one could avoid the COVID-19. The party invoking force majeure cannot overcome its effect. Cannot overcome its effect by any means. Now, in order to constitute a force majeure, the courts have recognized these three central principles that an event must have these three criteria. It must be irresistible, it must be unforeseeable, and the event must be external and must have the performance impossible. Take note, it must make the performance impossible. It means it's not only merely difficult. So it's not only difficult to perform, but it must be impossible. So take note of that. Now, how force majeure is defined in the international standard forms of contract, let's now consider the FIDIC rainbow suite of contracts. In FIDIC 1999, particularly the red and yellow books are the most common forms that is used in construction contracts in the Middle East and also in Qatar. Now, the concept of force majeure is recognized by FIDIC and was defined in subclause 19.1, which it says that force majeure is an exceptional event or circumstance that meets the following criteria. So what are these? One is the event is beyond a party's control. Second, which such party could not reasonably have provided against before entering into the contract. And then third, which have arisen such party could not reasonably have avoided or overcome, and which is not substantially attributable to either of the party. Now, note that these conditions are connected by the word, if you have seen, I have added it at the last, by the word "and," meaning all of these criteria must be satisfied. Not only one, not only two, not only three, so meaning all of these, because it is connected by the word "and." Now, in the new version of FIDIC forms, if you have already seen or familiar with the FIDIC form, with the FIDIC version of 2017, this form was published and issued on December 2017. And now, Clause 18 has the exceptional events, which replaces the Clause 19 that we have just discussed in the previous slides, FIDIC 1999. Now, concerning force majeure in an intention to obtain a much clearer language, they were saying, the term force majeure is no longer used in 2017 edition. Given that it took about a decade for the GCC construction industry to move on from the FIDIC 1987 forms and adopt the first editions of the Rainfall Suit published in 1999, there is a real possibility that 2017 version will largely remain on the bookshelf for the next few years in the Middle East, and that would not exempt Qatar. So now, if you would see, the exceptional event is almost defined the same as how it defined the force majeure in the FIDIC 1999. Now, up to the recent years, the FIDIC 1987 is still being used in UAE, which is 1987 is already superseded by the version of 1999. So for that reason, we will continue the discussion back to FIDIC 1999, which is your topic for the day, which is the force majeure. So FIDIC provides the following non-exhaustive list of events that could fall within the definition provided in the first part of subclause 19.1. So it says the war hostilities, whether it will be declared or not, or invasion or act of foreign enemies. If you would remember the blockade, they are now trying to consider blockade as an act of foreign enemy for it to be considered as a force majeure. So now the list provided, we cannot find from these wordings, even on the next slide, which is the continuation, munitions of war, natural catastrophes such as earthquakes, hurricane, typhoon, or volcanic activity. Now, this list provided is stated to be non-exhaustive list. So meaning it's not limited to what is defined in this list. So force majeure force majeure by the phrase may include but is not limited to. I have underlined it. So a force majeure may comprise but is not limited to any of the following events. Now, given the above four criteria of exceptional event defining the force majeure in the first part of the subclause 19.1, the COVID-19 as a pandemic has likely satisfied the definition quoted above. I'm sure you would agree with that. The pandemic is undoubtedly an exceptional event, which is also beyond the control of the parties. It could not have reasonably provided against before entering into the contract, and it could not have reasonably avoided or overcome. It could also not be substantially attributable to either of the parties. Now, you may say that you will consider pandemic as in the item number 5, which is a natural catastrophe, because you may say if it is not a man-made virus, it may fall there. So let's see if you would choose that category later on in the next slide. Okay, now subclause 19.2 provides the requirement of a notice of force majeure. Therefore, a contractor in Qatar who was prevented from performing its obligation under the contract due to COVID-19 and now invoking force majeure should have given a notice of the event. Now, the question is, by not later than when? The subclause 19.2 says 14 days. The notice shall be given within 14 days after the party became aware or should have been aware of the event or circumstances constituting the force majeure. So when are you going to start the count of 14 days? Which will it be from the time the ban of the entry of the non-Qataris or other people traveling in Doha, which was, I believe, implemented on the 17th of March of this year? Or would you like to count it from the 11th of March? That is the day when WHO labeled the outbreak as a pandemic. In any case, now my question to you is, have you already issued your notice of force majeure event? If not yet, my question is why? When would you want, or when would you wish, or when would you plan to issue your notice of force majeure? Because it is a requirement under clause 19.2. So now, subclause 19.2 alone does not expressly provide a condition precedent when a party has not provided the notice. However, we will see again about this on the next slides. Now, reasonable measures that could have been taken by contractors in mitigating the risk of delay on current situations in Qatar may include things like delivery by air, hiring of local available manpower. As we all know, even ADSLA is providing a list or a system, a portal for the list of all available manpowers inside Qatar, because it's very difficult or almost impossible to hire from outside. And another option is the people working from home. There are people who is outside of the country, but it's being considered to be working from home. I'm sure some of your firms are doing that. The second and the last paragraph of the subclause provides an obligation to a party to give notice to the other party when it ceases to be affected by the force majeure, which is, I think, it would still be a long time for now, not for the near future. Now, it says, each party shall at all times use all reasonable endeavors to minimize any delay. Now, the question is, how far all reasonable endeavors would mean in this subclause? It was not defined, it is not clear. The paragraph has no specific certain steps requiring the contractor on what to take as part of exercising its reasonable endeavor. If the contractor is required to sacrifice its own commercial interest? I doubt it if the contractors is willing to do that. Now, there is no set of criteria provided in this subclause that can be used in the assessment of what best endeavors mean that can be or should be taken by the contractor. Now, this last and the second and the last paragraph of the subclause of course, provides an obligation to a party, as I have said earlier, to give notice to the other party when it ceases to be affected by the force majeure. However, this subclause does not provide any express sanction for failure in giving such notice of cessation. So wala namang sanction if mag-fail ba siya ng pagbibigay ng notice. Now, interestingly, this subclause also failed to state an equivalent obligation to mitigate any other losses or consequences resulting from force majeure. Because what this it says, as I have underlined, it only says any delay. So, which may provide an opportunity. This is an opportunity for the contractor to argue between the parties that there is no obligation to mitigate anything other than delay, which is what? The cost, right? So, hindi binanggit about the mitigation of the cost. Now, FIDIC 1999 subclause 19.4, it is the consequences of force majeure. This clause, take note, applies only to the contractor. Now, remember, the subclause 19.1 to 19.3 that we have discussed in the previous slides apply to both the contractor and the employer. Now, the next subclause, the 19.4, only applies to the contractor. So, this subclause 19.4 provides an entitlement to the contractor to claim for extensions of time and / or cost. And it is subject to subclause 20.1. What is subclause 20.1? It is the contractor's claim. Now, only if the contractor is prevented from performing any of his obligations under the contract by force majeure. What else? The notice of force majeure must have been given under subclause 19.2. So if you have noticed, the notice must be given, diba? So the phrase is there. It says that the phrase of which notice has been given under subclause 19.2. Therefore, it is a clear requirement to an entitlement to any right of recovery of cost or extension of time under subclause 19.4. Next, subparagraph B of subclause 19.4 provides an entitlement to payment for any cost incurred due to force majeure if the event or circumstance is the kind of described in subparagraphs, if you still remember in the first slides, I to 4 of subclause 19.1. However, for events or circumstances listed under subparagraphs 2 to 4 of subclause 19.1, the entitlement for cost is only allowed if the force majeure occurs within the country. Anyway, it will not apply to COVID-19 anyway, because COVID-19 is almost all around the world. Now, these limits on entitlement to cost is tabulated in these slides for clearer understanding. Now, if force majeure is invoked due to, say, hostilities or act of foreign enemies, which is being related or considered during the blockade, it may have provided an entitlement to both extension of time and cost. However, if say COVID-19 or COVID-19 as a pandemic has satisfied the 8 test of the force majeure that we have summarized earlier, but it cannot qualify as any of the kind of events listed in the 19.1, or let's say if the pandemic qualified as a natural catastrophe, then the contractor may only be entitled for an extension of time but not cost. So now the question is, would you as a contractor choose to be considered yung pandemic as a natural catastrophe if the only thing that you would be entitled to is time and you will not be entitled for cost? For sure, hindi, di ba? Okay, now we are talking so much about cost, but what is cost really? I would like to define, to guide you with the definition of cost under FIDIC. And it is defined under subclause 1.1.4.3, which means what? It means all expenditures that are reasonably incurred or to be incurred by the contractor, whether on or off the site, including overhead and similar charges, but take note, it does not include profit. So it's like na parang reimbursable lang. Kung ano yung actual cost incurred, yun lang yung babayaran. Walang inclusion ng profit. So at least that's better kesa dun sa catastrophe na extension of time lang yung makukuha mo. Now, we mentioned subclause 20.1 earlier, and that is the contractor's claim. Subclause 20.1 is the contractor's claim. It is where contractor's claim is required to be compliant with the stipulated procedure that includes a notice provision with a prescribed period of 28 days. A valid claim may be deemed invalid and rejected on the basis of failure to comply with such procedural requirements. So again, take note how important the notice under FIDIC contract kung purely FIDIC talaga yung form of contract nyo. Accordingly, if the contractor, say, suffers delay or incurs costs due to an event, a notice of claim must be given within 28 days of being aware of such event for him to be entitled to an extension of time or additional cost. Otherwise, of course, the employer will be discharged from all liabilities in connection with such claim. So take note, time barring. Now, furthermore, this subclause requires that a fully detailed claim, including full supporting particulars, must be submitted within 42 days from the contractor's awareness of the event, and which we are assuming that was like early part of this year. Then it further specifies that in the event of a continuing effect, which is of course happening with the COVID-19, the fully detailed claim shall be considered as interim with further claims at a monthly interval. So you can do that in a monthly intervals in your payment application. So you can do that every 30 days. Then the contractor shall submit a final claim within 28 days after the end of the effects of the resulting event. So we don't know when would that end, when this COVID-19 would end, or could be, they were saying it could be a year or 2 years more, okay? So why we are now discussing contractor's claim? Because if the COVID-19 fails as as a qualifying event of force majeure, at all costs, the contractor has the right to claim under this clause as a contractor's claim. Okay? Now, the contractor, what's this? Force majeure affecting subcontractor. This is a clause that says if any subcontractor is entitled to relief from force majeure on terms additional or broader than those specified in this clause, such additional or broader force majeure events or circumstances shall not excuse the contractor's non-performance or entitle him to relief. So what does it mean? So the contractor should ensure that any subcontract is back-to-back with the main contract conditions in relation to relief from force majeure events. So we always know that if you have a subcontractor, or if you are a subcontractor as yourself, always ensure that when you are signing a contract, it's always a back-to-back with the contractor's main contract. So that's all for the FIDIC 1999 as a sample of international contract. Now we will move to the local standard form of contract, and we will examine how force majeure is considered in the general conditions of contract prepared by and issued by PWA that was in 2014. So as we probably know, or most of you know, that government infrastructure projects in Qatar are administered by PWA, which is also known as Ashgal. They have prepared two different editions of contracting contracts. It was started, the first edition was GCOC 1984. It was followed by PWA 2007. And then the latest one before the recent is PWA 2014. Now, the latest is the suit of contracts in 2018. It's like parang rainbow suit na siya, parang rainbow suit. And they were saying that it is now more contractor friendly, unlike the previous 3 editions. Now, other than PWA, some private owners and developers in Qatar have adopted the PWA 2014 in their own projects. So that's the reason, and force majeure is defined in PWA at subclause 14.1.1. So that's why I choose the PWA 2014 as a sample of local contract. So if you will say, if you see, it's defined. Clause 14.1.1 is an exceptional event or circumstance. And it says beyond the control of the affected party, which the affected party, despite all reasonable efforts, what else? Reasonable efforts could not have provided or required before entering into the contract. So most probably the definition is very similar with FIDIC 1999. So although it's different, you would see the last definition, masyado na siyang mahaba. Meron pa siyang binabanggit na reasonable skill, di ba? So how it differs with the other definition? PWA provides a list of events, including a force majeure at clause 14.1.2. Now, the above definition, so it says what? War, hostilities, whether war be declared or not, invasion, act of enemies. If you would see, it's almost similar to FIDIC 1999 version. However, the list of events provided in PWA is limited list with the words, I have underlined the word shall include any of the following events. Now, when you compared it to FIDIC 1999, the FIDIC has an non-exhaustive list, di ba? Because sa FIDIC, if you remember in our earlier slides, what did it says? May include but is not limited to. So meaning any events that satisfies the criteria may be considered as a force majeure. But here under PWA, it says shall include any of the following events. Therefore, if the event of pandemic or COVID-19 is not listed in those lists, it cannot be considered as a force majeure under PWA 2014. So it is a limited list, so take note of that. Now, go to clause 14.2, the notice of force majeure event. Although, as we already see, COVID-19 has a very a very little chance to qualify as a force majeure event in PWA 2014. Let's still discuss the other related clauses. So clause 14.2, notice of force majeure event. The notice period provided is only 5 days, which is of course way shorter than the 28 days allowed in FIDIC. Under subclause 14.2.2, the failure to give notice within the specified period required in subclause 14.2.1 will limit the relief of failure for performance to no more than 5 days before the date the notice has been given. Now, in this one, the affected party is required to give notice within 5 days after he becoming aware of the cessation of the force majeure event. So, meron ding notice na ganon. The term now here, 14.5 is now the duty to mitigate. So clause 14.5.1 provides each party a duty to minimize any disruption or delay in the performance of its obligation as a result of force majeure event and to resume full performance of its obligation as soon as practicable. Okay, so here's another term, as soon as practicable. So this term was considered by the court that the term as soon as practicable should not be construed to mean as soon as possible, or to mean that it was physically capable being served, but should not be greater. So it should be maybe more flexibility involved when you say as soon as practicable. Hindi siya as limited ng as soon as possible. So that's it. Now, clause 14.8 is the termination. This clause allows either party to terminate the contract upon service of notice of, say, 7 days. In the event that the execution of a substantial portion of the works is, say, prevented for a continuous period of 63 days or for a multiple periods with total to more than 100 days, which is nalagpasan na COVID-19, di ba? In a period of 365 consecutive days, even though wala pa tayong 1 year, pero malapit na, I'm sure as up to the next year, lalagpas pa yan, di ba? 100 days is just like more than 3 months. Therefore, the contractor shall then submit a draft of final account with 28 days after termination of the contract. However, with the challenges now, with the economy, with what's happening in the construction industry now, that there is a contractor who would initiate for the termination of their contract, because we know that most of the contractors is begging for awarding, right? So we just mentioned this, that it's within the PWA 2014. How it will be initiated by the contractor. Now, I just would like to mention local forms of contract and this such event of COVID-19 or special events mentioned or has been defined or referred to. Like for example, in Ashgal of May 2007, in under clause 65, it is referred to as a special risk. In Ashgal 2014, it is referred as force majeure, which we have discussed. The SC World Cup contract under clause 65 referred as a special risk. Kasi medyo ano yan, I think parang modified Ashgal May 2000 contract. And the Qatar Rail contract, majeure clause, which is under clause 19.4. And under this clause, the contractor is entitled to take note to any additional cost as long as the event is will satisfy the criteria of a force majeure under the contract. So now, if you will be asking, is COVID-19 pandemic force majeure? Now, my question, I will be throwing the question back to you. So what does your contract says? What does the force majeure contract clause or special risk or ano pang special event na how is it defined? How this event defined in contract? So now, when you go back to your offices, maybe tomorrow or on Sunday, so try to review your contract, whether it is a bespoke or an amended FIDIC or other local forms of contract. Try to check what specific laws refers to this COVID-19. Every contract is, of course, it's different, especially even the FIDIC itself. If you use the FIDIC form of contract, most of the contracts here who use FIDIC has an amendment. So sa particular conditions of contract. So you have to check the amendment that you did in the particular conditions of contract. Okay, so that's all for the international contract and some sample of the local local form of contract in Qatar. Now, let's see, as I have promised to you earlier, we will take a peek of a Qatar Civil Code. However, I would like to warn you not to use or not to, to quote this when you are drafting your correspondence, your claim, your reports. When it is all about legal, I would always recommend i-refer nyo yung client ninyo or yung firm ninyo to the legal department. You may give some overview about this. Oh, can you check, can you review this claim against these articles of the Qatar Civil Code, okay? So we will only be discussing this for our awareness, for some overview, but do not act beyond your competence, okay? This is a legal, it should be left to the legal, okay? This is just for our awareness.
Excuse me po, Engineer Asuncion.
Yes po.
Apologies for interrupting lang po.
Sure.
Can we propose for just a quick break para po ma-refresh po natin mga nasarili natin?
Okay, sure.
Just a 5-minute breaks para
sure.
Kayo na rin po. For
Okay.
Hindi po namin dire-diretso po ang ano nyo po.
Sige, iinom muna ako.
Alright. Yes, yan po. Sige po. Alright. So everybody, let's have a 5-minute break. If you have to go to the loo or have a water, that would be great. Good afternoon, everybody. Just a quick reminder or just a quick note. If you would like to ask them questions in advance, you can type it in the chat box and we will try to place it in a slideshow so that everybody can see the question that has been asked. Thank you. All right, so while we're waiting to resume our program, I would like to remind everyone to please use the virtual background, which has been sent through the chat box. Am I right? All right. So just kindly check the chat box for the virtual background. Then we would like to again remind everybody for the protocols or the house rules that we have mentioned a while ago. Please be reminded to follow the name format. All right, so we'll start again with the PDC house rule, which is number 1. Certificate will be issued to those who will comply with the assessment to be given at the end of the webinar, acquiring 50% passing rate and completed at the required time. Number 2, please follow the proper standard of naming, which is PRC number underscore, followed by your surname, first name, middle initial. Participants shall be prohibited from turning off their cameras. All participants' microphones will be turned off during the duration of the seminar. Attendance will be based on the registration and those who are in the Zoom room only. Please observe proper dress code. So again, the virtual background is in the chat box. And I realize I'm also not doing it, so I will look at the chat box as well now. Engineer Asuncion.
Yes.
All right. Maraming salamat po. Thank you, everybody. So we can resume the presentation now. Are you ready na po?
Apology, ha? Hindi ko ma-change yung background ko. Hindi ako ganun kateki dito sa...
Wala pong problema po. Thank you very much po. Sige po, we can resume the presentation na po.
Okay, thank you so much.
Welcome.
Okay, so, proceeding now with the Qatar Civil Code. So the state of Qatar, like most parts of the Middle East, is primarily a civil law jurisdiction. So Sharias or Islamic law, if you have heard it, is the principal source of its legislation, and it is enshrined in Article 1 of the Permanent Constitution of the State of Qatar. Now, all Qatari laws are issued in Arabic, and there has no official translations. In terms of interpretation of the law, take note that Arabic takes priority over any translation to other languages. So for English translation purposes of the Qatari Civil Code, for this presentation alone, I have used the reference in Qatar Legal Portal, which is the Al-Mizan. Okay, so now the Civil Code has no full definition provided on what constitutes for a force majeure. It is narrowly acknowledged as an event beyond the person's control at Article 204. So if you have seen, it's on the screen, Article 204 states that where a person proves that damages have arisen from a cause beyond his control. So I have underlined that word. So parang it somehow defines the force majeure event, okay? So that's how it's only, this is how force majeure was acknowledged in this article. Now, in Article 169, this enables the court, where the parties' intention are not clear, to examine the industry practice. So if there are unclear intentions stated in the contract, the court can refer to or examine what the industry practice relating to the issue. And the previous course of dealings, for example, between the parties to ascertain the meaning of the wording. So kung may mga medyo vague na terminologies, yung mga previous correspondence. So it could be during the tendering stage, diba? So Qatari law recognizes that the parties' rights and obligations may be extended beyond those expressed in the contract. The court may also look beyond the literal meaning of the words in the contract and consider the mutual intention of the parties in certain circumstances. So such as obligation to act in good faith. So take note of that, which is the subject to the express terms of the contract. So Article 1692, it says where a contract must be construed, the common intention of the party shall be sought without restriction to the literal meaning of the words, taking into account the nature of the transaction, as well as the honesty and confidence that should prevail between the parties in accordance with commercial custom. Now, here is the Article 171. The overriding principle at Article 171 states that a contract is the law of the parties. So that's why most of the time the court will only tell the contracting parties, go back to your contract, what is stated in your contract. And so it cannot be revoked or modified except with the agreement of the parties or for such reasons as prescribed by the law. Now, the general principle enunciated at Article 171 is that pax sanct servanda, which is referred to as the freedom of contract, which is the freedom of the parties to contract. This general principle is also reiterated at 172 paragraph 1 by stating that a contract must be executed in accordance with the contents thereof and in a way that is consistent with the requirements of good faith. So dito na pumapasok yung requirements of good faith, na ito yung lagi ng ginagamit ng contractor pagka medyo referring to Article 172 and everything must be consistent with the requirements of good faith, diba? So I'm sure ito yung medyo familiar tayong lahat, yung Article 172.
Si Gilbert nasa CR pa.
Okay, now termination of the contract under Article 188 due to force majeure that is beyond the control of the parties requires the contractor to establish that the performance of its obligation becomes impossible and not only simply difficult. So eto na naman siya. The obligation must be impossible. So I don't think that there is much obligation under the construction contracts that cannot be 100% impossible to deliver by the contractor. Maybe there's a lot that's difficult, but that is impossible. Maybe it's partial delivery or partial impossibility is possible. In the occurrence of COVID-19 pandemic, we could say that it's a partial impossibility is likely to be considered. Now, the contractor may be requested to perform its residual obligations that remain possible to perform or he may request for the dissolution of the contract. Okay, so it still depends on the two parties. Now, a contractor is not deemed to be liable for failure to perform his obligation or delay in performing its obligation if such failure or delay is due to an event beyond his control, which may include, of course, the COVID-19 pandemic. Now, this article does not expressly deal with the issue of fault or acts on the part of one party, but it rather expressly refers to a failure to perform an obligation due to extraneous cause. Okay? So now, while in Article 258, this allows the parties to agree within their contract that the liability for the consequences of force majeure or unforeseen event shall be allocated to the contractor. So what this refers again, you still have to go back to your contract. What is stated in your contract? So accordingly, where a contract incorporates a force majeure provision that specifies either exclusive or inclusive list, as we have, if you remember how we compared the PWA 2014 against the FIDIC 1919, when there is a exhaustive and a limited list of events, then such clause will be valid, binding and enforceable between the parties because of this clause of 258. Now, the concept force majeure is contained in Article 402 of the Qatari Civil Code, and it says, obligation shall cease if the debtor can prove that their fulfillment has become impossible due to a foreign cause beyond the control of the debtor. Now, the term foreign here in the above translation was interpreted by some of the lawyers as an external or as an extraneous cause, which may constitute as a force majeure. So it all again depends on the lawyer, on your lawyer, on how what would be his translation of this foreign terminology from Arabic to English. Okay, Article 700. This article provides entitlement to the contractor for the price escalation due to exceptional event, in which price escalation, of course, is a likely consequence of COVID-19 pandemic, di ba? Lahat na tumaas, lahat na nagmahal, except lang what? Yung mga salaries. Due to the limited options available for importing raw materials, importing supplies, resources, equipments, and everything. Although, merong limited, engineers, architects, laborers, may limited source pa rin dito sa Qatar, but we don't know what happened. Bakit yung salary offers is mas bumababa daw, di ba? Dapat daw pagka high demand then low supply, dapat di ba mas mataas yung prices. Okay, so now we are in the conclusion stage. So what can we conclude for now? Let's see. If a force majeure event does not transpire to be a true force majeure event, then any failures in the performance, such as suspension of the works, may render a party vulnerable to a claim for breach of contract. So now, before the contractor could declare a suspension or termination, you must be very sure na yung event or COVID-19 is clearly qualifies, 100% ka na sure na it is a considered force majeure under your contract. In providing a definition of force majeure in the contract, we must be very cautious on the use of vague words in the contract. What are these? We have mentioned this in the previous slides. Special circumstances, as soon as practicable, di ba? So it is important to ensure that these terms, use, and intentions of the parties are very clear. Kung may mga ganitong words, it is better na i-define siya within the contract. So if you are still in the stage of preparation of the contract, try to check if may mga ganitong terminologies in your contract before you sign it, and try to clarify or define it as early as possible. Now, provide separate clauses for events that would make the performance of a contract fully impossible and partially impossible. So if you could differentiate events that could be fully or partially impossible to perform, try to differentiate it in your contract. Now, the drafter may consider what the parties wishes to receive out from the contract in the event of partial performance. So kung may partial performance of obligation due to force majeure, special circumstances, pandemic, whatever, so be sure na clear kayo, both parties, ano yung marireceive ng one parties or the other party. A force majeure clause may not always allow the termination of the contract. It may continue to survive with some revisions of the obligations of the parties. Whether the contract is standard, amended, or bespoke form, careful thought should be given to the potential consequences of each event, such as force majeure, and how this risk should be allocated prior to entry into the contract. So I'm sure after this pandemic crisis, lahat na ng mga new contracts nandiyan na yan. Parang yung blockade dati, yung blockade lagi na, so ngayon yung blockade, yung pandemic, yung COVID-19, so lagi na yan, makukonsider na natin for sure in the future drafting of contracts. In drafting a force majeure clause, it is important to reflect what the parties have contemplated with regards to what constitutes a force majeure event and what are its consequences, including the following elements. One, there must be a clear definition of what force majeure events is. What actions are required from each party when an event occurs. Anong action? May notice bang kailangan? Up to what day? From what date? 14 days from what date? So be specific as much as possible. Is suspension of performance allowed? You have to discuss, would you allow suspension? So if yes, who would allow to suspend? Is it the contractor, the client, both, either po? So it should be agreed. A provision in the event that the force majeure continues for more than a specified period of time. So kung magko-continue yung nabanggit natin kanina, di ba, for a period of 100 days lang, what if it is more than? So be specific with the period na pag may mga extended events like this. Now is another thing is termination allowed? So the party should discuss this. If there is a termination, just the same with the suspension. If it is allowed, who is allowed to suspend? Is either of the parties allowed to suspend or not? So I think that concludes my presentation about force majeure and construction contract in relation to COVID-19. So I wish you all to have a good day and thank you for inviting me here. I think we have a question and answer portion after this. So back to the host.
Thank you very much, Architect Asuncion. Engineer, sorry po. Medyo na ano ako dun. All right.
No worries.
So, we will now proceed to the question and answer. So I believe that there are some members who have already, or some attendees who have actually sent their questions, and we have prepared the slides for Engineer Asuncion. All right, let's start with question number 1.
Parang ang liwanag ah. Nababasa ba yan?
Ako po. Ako po ba yung maliwanag? Apologies guys, I'm dark here.
Oo nga, white eh, tapos may ilaw na white. Sige, okay lang.
Yes, tinatawag na po.
Ayun, okay.
All right. Question number 1, let me read it for everybody. Can we claim for time and cost under change of law due to pronouncement of government to stop COVID-19?
Can we claim for time and cost under change of law due to pronouncement of government to stop? To stop? Is that tama ba yung question? To stop COVID-19? Parang medyo may ano doon sa question. Ano? Now, I will throw back the question. Is there a change of law? I think the first question here is, while the contractor will be claiming time and cost for a change of law, the clients will now throw back, is there a change of law? Wala naman, di ba? How would you define the change of law? Meron bang law na binabase in here? Wala, di ba? May law of 2020 relating to COVID-19, di ba? Walang change of law officially. So anong pagre-referan natin na change of law so far? However, you were saying, yes, sure. Who's that?
Good afternoon, ma'am. The question is not mine, pero itatanong
Yes,
ko lang, itatanong ko lang po, ma'am, kung for example, ma'am, sa case ng lockdown doon sa industrial area, no, di po ba may ibinabang announcement yung ministry na dapat mag-stop muna yung work doon, walang operation, may lockdown. Should we consider it as a change of law, or how do we call it, ma'am?
no, it's not a law. It's not a change in the law. Kasi, like for example, are you familiar with the recent changes of law in the labor? Yung wala ng NOC by early March ba yun? And then the change of labor law with regards sa notice of termination or resignation or separation from your employment. Ganon yung mga law. Talagang merong law 2020, law 19 of 2020 relating to COVID-19 or whatever. Wala pa so far. So, if you are a contractor and you will say na you are claiming again because of change of law, immediately ang sagot sa'yo ng client, is there a change of law? Wala, di ba? Hindi siya change of law. Now, of course, nagkaroon ka ng disturbance nung nagkaroon ng community quarantine in the industrial area, but it cannot be considered as a change of law. Of course, the contractor has always right to claim kapag kami mga ganong additional cost, disruption, you can consider as a claim. But kung babalik ka, i-claim mo siya due to force majeure again, babalik tayo. Is COVID-19 considered as force majeure under your contract? So what is your form of contract? Is it bespoke or standard form of contract? So babalik tayo doon. Now, going back to this question, whoever throw this question, my question is, can you tell me what is the change of law in Qatar so far? Wala akong alam. Yes.
All right, so hopefully, well, there's no change of law, I believe, just policies or just
Exactly, may mga policies lang, yes. You're right in there.
So I think that's the right term for there, if the policy will affect any of the claim for time and cost.
Yes.
All right, so the question came from Irvin. So hopefully that answers his question. All right, so the next question, engineer, is from Frederick Fuentes Pina. So here's the scenario. The contractor submitted claim regarding force majeure in COVID-19. The contractor write in their claim submission that due to the pandemic situation that occur in the construction site, their profit becomes less and their productivity is also less because of course of the precautionary applied, like working distance apart. Also, their labor or workers are infected by COVID and penalty should not be applied. The question, is the contractor entitled for extra profit and extension of time?
Okay, so it looks like wala siyang binanggit na force majeure. So probably there's no force majeure clause under dun sa contract niya. Now, he wants to claim for additional pakibalik mo naman yung wag mo akong i-view muna. Gusto kong basahin yung question habang sumasagot. Can you share the question again, please? Yung
Sharing
face
at the moment.
nakikita ko eh. Sorry. Okay, thank you. So the question is, the contractor submitted a claim. So by mentioning the force majeure, ibabalik ko sa iyo. If you are considering COVID-19 as a force majeure, I will now return it back to you. May force majeure clause ba may force majeure provision ba sa clauses ng contract mo? If yes, you have to refer there. Okay? Contractor write this due to pandemic situation. So you must be sure na yung pandemic situation, yung COVID-19 is within the qualification or criteria of force majeure under your contract. Second, ang concern niya is extra profit. Now, the question is, does your contract allows for profit? Kung mapapansin niyo kanina, dinefine ko yung cost, di ba? So, if you are using FIDIC, the contractor is entitled for cost and time. So yung time, alam na natin yan, extension of time. So kaya ko dinefine kanina yung cost is because what is cost under the FIDIC? Cost is anything that the contractor incurred or should be incurred whether on or off-site, pero excluding profit. Now, how does this cost defined in your contract? Defined ba siya? If not, so how can you claim for profit? So ibabalik ko rin yung question sa iyo. So you go back to your contract. Is it allowed ba? Now, extension of time. It's most probably yung COVID-19 kung magko-qualify siya as force majeure under FIDIC. So extension of time is can be considered kasi kung nandun siya sa last item na pwede siyang ma-consider yung item 5, diba? Like natural catastrophes, if you would be considered as natural catastrophes, definitely entitled yung contractor for time. So ang main concern is yung time kasi hindi mahirap yan na i-claim sa client eh. Ang mahirap i-claim is what? Yung cost incurred or to be incurred by the contractor. So ang point ko dito is while everyone is focusing on the force majeure clause, why don't you focus on the construction claims under 20.1? You can claim anything there. As long as masasubstantiate mo siya as a cost incurred by your company under the contract, which is beyond your control, na hindi ikaw yung nag-initiate, di ba? COVID-19, hindi naman. We are not the one na nag-cause naman ng COVID-19. So definitely, mas mag-focus ka dun sa contractor's claim under 20.1 instead na mag-push ka sa force majeure ng COVID-19. Kaya hinalight ko kanina, willing ka ba as a contractor na ma-consider yung COVID-19 pandemic as a natural catastrophe and then it will be now considered as a force majeure and you will only be entitled for time and not for cost? Definitely not. Now, hindi lang cost yung hinahabol mo, even profit pa. So doon ka pumunta sa claims.
So we would like to proceed with the next. All right, thank you very much again. So we'd like to proceed with the next question. Okay, a question from Miluna Aligada. What are other remedies or other ways that the contractor could have in order to cover any losses caused by the pandemic?
Remedies. We have mentioned earlier yung mga like for example, to avoid further delays, pwede kang magpa-air kung previously ang lead time mo is matagal because of sea freight, so pwede kang magpa-air freight ngayon. Kaya lang anong consideration doon, 'di ba? May cost. It could come earlier pero may cost. So with regards to resources like labor, engineers, architects, other professionals, you have no choices. Kundi talagang mag-hire lang locally because you cannot hire from abroad. What else pa? I think you are remedies ba? Remedies or mitigations you are remedies in order to cover losses? Kasi to cover losses, mitigation lang talaga. So ano yung mga mitigation? Work from home. As I have mentioned earlier, kung yung staff mo is abroad and then capable naman siya to work online, pwede siyang makipag-attend ng online meetings and then meron siyang pwede siyang makipag-communicate ng mga correspondence online, pwede siyang gumawa doon ng mga designs from wherever country he is, which is also happening in our firm. Some are in the Philippines, some are in other countries in the UK or other parts of the world. They were allowed to work from home, from their own country. So that is another option. And then kung open na, kung allowed na, may permit na to come in, and then that's the time na pabalikin mo siya dito. Or another option is, of course, sabi nga, kagaya ng what ADSLA has did, meron ng list sa ADSLA website. Whoever yung mga professionals na nandito, maraming mga unemployed, di ba? So pwedeng you can hire from there. And of course, as you know, yung mga offers from them is hindi na katulad ng mga offers from before. So materials, I think, what else can we do? As long as you place the orders as early as possible or within the time frame, and then, yes, sure.
Sorry, we have international guests, so we are requesting for
sorry.
short English. Yes,
apology for that. Okay. Sure.
We take two.
Okay, so I hope I was able to answer Architect Miluna on her questions about the remedies. I think that the best is to maximize resources that is within Qatar as much as possible, and then place materials, orders, or procurement abroad as early as possible. That's all that we can do. And of course, take the opportunity of working from home, yung mga those employees, even those people who are under home quarantine or those people who are in hotel quarantine for 14 days. We are having project meetings that some of the contractors attending are there in the home quarantine. So that's all. Unless you would like to expound more your question.
Thank you so much, ma'am. Actually, you answered my question. I just want to note as well the one that you said earlier, stressing that the pandemic effect, I mean the losses and the effects of pandemic in the construction should not be focusing. I mean the claim should not be focused on the force majeure, instead in the contractor's claim.
Yes,
so that is clear on our side. And actually, I just want to note as well that you were saying before that these remedies could give us more cost in the construction. So therefore, this means, ma'am, that whatever is the extra cost that we have as a remedy, it should be notified to the client. Is it correct, ma'am?
Yes, I'm sure. The only thing that the contractor wants is, I'm sure that the contractor would like to, as I mentioned earlier, to expose his resources, his commercial, his commercial support to the project. However, his main concern is how can he recover it from the client. So as early as possible, give notice to the client. Gives a heads up as early as possible, because everyone knows about the additional costs that will be coming. Another one is, what's this? The recent one, the minimum wage. Diba? There's the minimum wage law. That is a law. So everyone would be entitled to that.
Okay, ma'am. Thank you so much, ma'am.
Okay, thank you for the question, Architect Miluna, and thank you for your insight, Engineer Sunshon. We have one more question. The question is from Jonathan Barreto. If the contractor is late to start the project due to recent pandemic issues, can the contractor ask charges and extension of time?
Why are you late to start the project? So if you, I would assume that when you were awarded the project, there's already a start date. So if you were able to start late due to pandemic and the cost is can be fully substantiated, why not? I was telling earlier that anything can be claimed. It is a right of the contractor to submit his claim. The only a common problem is how would you present your claim? Just be sure that you have the proper notice required under the contract. You have the supporting documents. Make sure that everything is what is recorded. So always record the all the events that is happening so that this will support you even if at the later stage of the project you would decide to declare it as a dispute. If you would not agree with the client, so at least you have a full record that will support you even you go to arbitration or you go to the court. So yes, the question is, yes, you could ask. The question is how the client would award you the claim, diba? So the question is, it depends on how you present your claim. You have all the rights to submit the claim, but my recommendation, my advice to the contractor is always keep the records. It is the only supporting document that will make your claim stronger.
Good. There's a follow-up question from Architect Miluna. All right. The question is, what are other remedies or other ways?
That's all.
Wait. It's a follow-up question, I mean. For that question, the follow-up is, can a contractor claim pandemic against the project insurance?
Can a contractor claim pandemic against the project insurance? What type of insurance?
OSIP, ma'am, for example.
Sorry?
Yung OSIP po na provided ng client, the one provided by ASHGA, the PWA, or CIP. I am not so familiar, but recently they have given like guidelines to protect the project and stuff in order to claim insurance from the insurance.
It all depends on what type of insurance, because the insurance itself has its own if the contractor hindi yan. So it depends on what type of insurance can a contractor claim pandemic against the project insurance. It depends what type of insurance are in place. So I want to know what type of insurance you are referring to and what type of claim are you going to file to the insurance company, because every insurance is specific to its needs. So what insurance do we have? Contractors all risk. We have the employment compensation, right? So what else insurance do we have? So it depends of what insurance is in place in your project. Unless you have a specific project insurance covering pandemic case, do you have that? Yes.
No, ma'am. It just triggered my mind because they have given some guidelines to prevent OSIP itself. they have given these guidelines to protect the project from the pandemic. So I was thinking that maybe because they themselves have given this guidelines, there could be a possible claim or that could be done.
Okay. Insurance is always specific to the needs of the person or the event insured. So it would all depends on the policy itself. So you have to go just like the construction contract. Anna, we are saying go back to your contract. What is stated in the contract? So I cannot answer that directly. It depends that I would like to see the insurance policy. What is stated in the insurance policy? For sure, the policy clearly states what is covered by that policy. So it depends. It depends on what insurance you have in place.
Okay, ma'am. Thank you.
We have a question from Mike Garcia. So I'll just read it for the meantime. It's, will there be changes, upgrade on FIDIC documents related to this COVID pandemic, or the current available templates are good enough to keep substantial contract arrangements? Any early news as of date?
As we all know, the FIDIC is constantly updating, constantly upgrading. However, the recent was is 2017. Although it was issued, when was it issued? December 2018. So it's fairly new. I doubt that there would be new, versions of FIDIC that is intended to be released in the near future. However, I have already mentioned to you, diba, that the force majeure itself is no longer in FIDIC 2017. So it's already a special circumstances. So from that, the terminology alone, the pandemic may be considered in the qualification or criteria in the FIDIC 2017. However, as early as today, I'm not sure if there's already a contract or an existing contract in Qatar which is based in the FIDIC 2017. So if you are looking for a new version, again, we are not even very much familiar with the 2017 version, and it would be very difficult for the construction professionals to have a new version again ng FIDIC. So I don't think there will be. The 2017 terminology is already flexible enough to consider pandemic, I believe so.
We have a follow-up question. Thank you for that question, Mike, and for your feedback, Engineer Simpson. I believe we have another follow-up question. This is a follow-up question to Jonathan Barreto's question a while ago. What could be the substantial documents needed to support the right of the contractor to ask for a claim or extension of time due to the pandemic issues?
Oh, there's so much. You have the daily report, the correspondence letter, the notice that you have issued. If you what depends. What are you claiming? Are you claiming for employees working from home? What are you claiming? Are you claiming for additional cost of materials, additional shipping cost of materials? So things like this should be supported by invoices. Increase in material costs, increase in cost of machinery. So you have to support your original cost against your new cost. Earlier you were saying, one of the attendees is saying about changes in law. If you are insisting that there's a change in law, you have to support that there is indeed a change in law. So if it's not a change in law, so what support do you have on hand? Most of it are correspondence, letters, records. Daily reports is very important. Do you have, did you pay workers who are in quarantine? So you must have the record of that, COVID tests, medical reports, and everything. So all of this has to be compiled. Actually, the documents will be huge. You could fill up maybe a room for for this claim. So if you will be claiming for minimum wage law, of course, you have to present your salary list before compared to the new law requirements of minimum wage. So things like that. We are all familiar with the submission of claims, although many contractors fails on the proper presentation of claims. I think that's another topic that's also interesting for us in the construction industry. But I will tell you, the only thing that we have to remember is record. As long as you have a record of everything, I'm sure you could win the claim against the client.
Architect Jonathan, are we happy with the feedback?
Yes, sir. Thank you.
All right. Thank you very much for that question, and thank you again, Engineer Asuncion. So do we have any more questions for Engineer? We have no more questions. So Engineer, do you have any closing statements for us before we wrap up your segment?
Of course, I just want to thank everyone, all of the architects here who are present here. Thank you for the UAP Qatar Chapter for inviting me here.
Much pleasure.
It's good to know to have this as what Miluna says, a joint forces between the quantity surveyors and the Filipino architects in Qatar. So I really appreciate your invitation and being in attendance to one of your webinars. I wish you more power, more support to your organization, and I also would like to invite you to join in one of our events and CPDs through Architect Miluna.
All right, that sounds like a good plan. So, all right, to proceed, we would like to officially give you our token of appreciation for being a speaker for this afternoon's event. To do that, I would like to invite Architect Samson Huntilla, our chapter director for Committee on Professional Practice, to present you with our token of appreciation.
Thank you, Engineer Asuncion. In return, we would like to, as the United Architects of the Philippines Qatar Chapter, we would like to present you this certificate of appreciation. Of course, this is in collaboration with PICQS Qatar and the Architects Hub. I would just like to read the message. Certificate of appreciation is given to Engineer Asuncion B. Lopez, the President of PICQS, our guest speaker. UAP Qatar Chapter is appreciative for the shared point of views as seen and observed by the speaker, bringing forth more informative matters in architectural design, recognizing the force majeure as an element in planning. The topic, force majeure, given this 30th day of October 2020 by a webinar meeting, signed Architect Mario Herman M. Macaranas, UAP Qatar Chapter President, fiscal year 2020 and 2021, and noted by Architect Faranil C. Dules Reyes, UAP Qatar Secretary, fiscal year 2020-2021. Thank you once again, Engineer Asuncion.
Thank you so much.
All right, so I guess we'll have a picture taking.
Sure, ma'am. Thank you so much.
The Zoom picture taking.